Hello, hello, hello. Hi, everybody. How are you this evening? Good to see you. I appreciate everybody being here. I'm super excited to talk to you guys tonight. I'm sorry that I put this live off. There's a couple of um, things that I want to talk to you guys tonight about, and I wasn't exactly sure how to do it. Plus, I had to call in for backup because I wasn't understanding some of the things that I was seeing. So, what I have for you guys tonight is, um, like I mentioned, I don't know if you missed the lunch with Lou live. I did. I was actually talking about Alex Murdaugh and his appeal for a new trial based on jury tampering. His defense claims that there's been jury tampering on the part of one Becky Hill, and she's being looked into. But anyway, at the very end of that, I was telling you guys, I was saying that, um, the Sarah Boone's attorney basically filed claiming her, saying, "Hey, it's me. I'm her attorney. Hi, okay." So there's that. But he also filed what's called a motion for statement of particulars, and I saw that this morning, and I wasn't 100% sure what it is. So, of course, I hit the Googles because I am not an attorney. So, I went and looked at it. Basically, it's a motion asking the court to order the state attorney or prosecutor to disclose more specifically what facts the state will attempt to prove that constitutes a crime. Okay. And so we're going to go over that. And also, super big, huge shout out to B Crumbs, because B Crumbs requested the call logs and the visitation logs for Sarah Boone. Now, the parts that, oh no, Mayla's mom. Last night while on your live, I dropped my vape in the bathtub. Oh my gosh, I'm so sorry, babe. I'm so sorry. I'm so sorry. That's awful. That's awful. Um, so anyway, um, I forgot what I was saying. Oh, B Crumbs requested the visitation logs and the call logs. And the parts that I'm interested in are um, mainly the professional visits. And the reason being is I have somewhat suspected for a while, but there was no real way to prove it, that when Sarah was writing letters to the judges, that she was exaggerating, and that there was work being done on her case. And the reason that I mention this is because she made some really like hefty, lofty allegations against her attorneys. Okay. And I don't like to see anybody be falsely accused. So if the things that she alleges that these attorneys did, which is basically not communicate with her at all, and when they did, specifically in like her first attorney, Padilla, she alleged that when he did communicate with her, it was never about her case. It was about, random other stuff in his life. And the fact of the matter is, when it comes to that, it's not just because Sarah has her case, because it's so, it's not one of those, it's not something that unfortunately and sadly, people are unalived every single day, and that's really sad. It's the circumstances under which she did this that have caused so much attention to this case, right? So when she puts in letters that her attorneys don't communicate with her and they're unprofessional. And, like with Cashman, I had to, pretend to be a judge, which I don't even know how that's supposed to work. And, I walked out of my interviews, my meetings with her, blah, blah, blah. That's a big deal. And I also wanted to mention it too, because tomorrow there is a hearing. Okay. Now, what was supposed to happen is Sarah made a big kerfuffle, an oral kerfuffle, if you will. She made an oral motion before the court. She did not want the media to be present while she viewed her the state's physical evidence. Okay, she thought she ought to have privacy for that. Blah 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 blah. Right? We all watched that, and so the state said, okay, this is what we're willing to do. We recognize that this is, unusual circumstances in that she is a pro se defendant, and ordinarily, the looking over physical evidence wouldn't take place in open court. So here's what we're willing to do. We're willing to do it down at the jail. Okay. Well, that was supposed to have been done prior to September 3rd, which is tomorrow, right? And the judge said, I'm going to need proof of that this happened and all the things, right? You have to file something. And the state said, Sarah asked a question. She said, is this something I need to do? And the state said, no, we're going to handle all of it. Okay. Well, we were talking about this Friday or Thursday at lunch. And I said, this is Thursday or Friday, whatever day it was. I said, they're really kind of running out of time to have the evidence. Well, now it makes sense because Sarah was intending on, having an attorney. So, they're running out of time. But, now, of course, we know she secured an attorney. She retained an attorney. How she retained, I think this is an interesting situation and scenario because Sarah has been declared indigent, and the motions that her attorney has filed denote that she is indeed indigent. So did she really retain this attorney? Well, no, because usually when you retain an attorney, right, there's money exchanged. It's still a retainer, but she didn't pay for the attorney. Okay. He still agreed to represent her. But the deal is, and this is what is going to be interesting for me, and I'm very curious how this is going to get handled. This attorney is wanting expert witnesses, etc., right? But he's requesting that the JAC pay for it. Now, this is why I'm curious about that, because these are things that Sarah was probably already going to have the JAC. She already wanted a neuropsychologist, okay? And so they have already shelled out quite a bit of money for expert witnesses that were requested by her other attorneys. It seems to me that all of the attorneys that have worked on Sarah's case thus far really have this. The defense that they were going to use is battered spouse syndrome. Okay, and so they were preparing for that, and then I think Sarah was going to go along with that. So in that arena, she trusted them. So this is where it's also confusing to me where the conflict came in between them. What exactly is it that she wanted them to do that they were not willing to do? I mean, they used the term ethics, and that means something. So I don't know, but so what's interesting to me is the JAC was probably going to go ahead and put that money out anyway, right? So, but I'm curious how this attorney intends to be paid, or is he truly doing it completely pro bono? Because if he's doing it completely pro bono, then I don't think that he is allowed to bill the JAC. So I'm very, very, very curious how this is going to go tomorrow. And I'm going to be waiting with you guys. The hearing is scheduled for 9 a.m. Okay, that's Eastern time. Now, what Judge Kranick, it seems to me, has been doing is, because I know when when the hearings are. And so I start I start an hour before, sometimes 2 hours before, looking for the notification of a stream. And so I think what happens is that Judge Kranick has said, okay, I don't mind there being cameras in the courtroom, but what we're going to do is you can record, and then after the court has ended, then you can upload the footage. So I think that's what's going to happen tomorrow, and I'm very curious about that because, and I think that is reasonable. I think when it comes to the trial, I think that it'll be streamed, and that's different. Okay, the first thing I want to show you guys, though, is something that I shared on my hang on just a second, community tab, and I don't know if you guys saw it. Let me just look. I really don't care for that thumbnail. It's really bothering me, and I'm probably gonna have to do it again because I really don't like this. Hold on a minute. Let me see. What? Okay. He changed it to members only. So obviously it doesn't work for me to have shared it. All right. So Mentor Lawyer uploaded his thoughts on Sarah Boone and her being represented now. And, what he said actually made a lot of sense to me, and it really made me think. Basically what he said is that when we don't want the trial to be a circus, because it doesn't really do anything. It doesn't really benefit the justice system as a whole when we have a trial that has a circus atmosphere. And I think with Sarah Boone representing herself, you guys, we're all familiar with her brand, right? But I think, and I agree, and I agree with him in this point too. More importantly, at least to me, more importantly, is that the trial is about, for the state really, is about seeking justice for the victim, and George Torres is the victim. He's the one who lost his life. Sarah Boone is not the victim in this case. While there was a tumultuous relationship that existed between she and George, and they were both the victim and the perpetrator at different times of domestic violence against the other. Ultimately, George is the victim. He's the one that lost his life. And it's really, for me, about his family. And instead of playing the Mentor Lawyer one, I'm going to play you guys something that I watched. It's old. It's an old one that I watched a long time ago, but because I've been talking about Sarah Boone, it came back up in my feed. And I want you, it's George's mom, and she speaks to News Nation. And I want to play this for you guys because I think it is really important for us, to remember that George is the victim. He is the one who lost his life. And because of the letters, and it's not just the letters themselves, the contents of those letters, the length of the letters, the things that she wrote in there, the allegations that she made. And now it's all, culminated in isn't allowed to, to have use of the public defender's office, which also then caused a ton of hullabaloo. George has been lost in this, and I think that's really sad. And welcome Jade Raiders. Appreciate y'all being here. And so I think it's important that we remember exactly who is the victim in this situation, and what all of this has really done to his family, who's been waiting and waiting and waiting. I mean, she was charged in 2020, you guys. And you can give some, like, okay, that was during the pandemic, and so things, got slowed down and all of that. But there are many other people who were actually charged for their crime after Sarah Boone, who have already been on trial, So I think it's important. So I want to play this for you guys, and then we'll talk about it, and then we'll get to this latest motion and what it means and all the things. Okay, so here we go.
Years ago in Winter Park, Florida, George Torres was zipped into his suitcase by his girlfriend. Why Sarah Boone did that? She says it was a game of hide and seek, but she's going to have to tell that to a jury. Because she whipped out her phone afterwards and videotaped him begging for his life as he slowly suffocated. Up until now, his parents have not spoken, his family has not spoken, but tonight they are. I'm joined by the reporter who got that interview for us, News Nation national correspondent Alex Capriello. He joins me live. That trial is coming up July 4th, and you are hearing exclusively from the parents. What did they tell you about what they know about the case?
Yeah, it really dawned on me, Ashley, that there's been so much attention on Sarah Boone, so much focus on the bizarreness of this trial that perhaps no one has ever really taken time to speak to the Torres family. And it turns out my suspicions were correct. Within the 3 years since Sarah was arrested, they haven't spoken to any national or local media outlets, had the chance to say their side of the story. So we sat down at their kitchen table, and they really just opened up to me all about who George was, what he meant to their family, and also, of course, his relationship with Sarah, which, by the way, they never approved of. But interestingly, Ashley, George's mother tells me that she has a great deal of sympathy for Sarah, because if she is convicted, she'll never have the opportunity to raise her son like she did with her many children. Take a listen.
He was a good son. He wasn't perfect, but he was a good son. And every time that he come here, every time, he just stand in that wall and he said, Mom, I love you. Mom, I love you. I said, I know you love me. They come and give me a hug. And then he look at his father and he said, Pop, you're my hero. You're my hero. He was a father. He was my son. He was an uncle. He was a cousin. And he was a friend. And he was a nephew. She don't kill only my son. I feel sad for her. I don't feel sorry. I feel sad. And I don't hate her. Really, I don't. I don't have that in my heart. I never hate nobody.
Gosh, so powerful to sit there with her as she explained more about her son. Interestingly, she said that she's never seen that cell phone video that shows George locked up in that briefcase, or I'm sorry, that suitcase. She says she has no intention of seeing it, but she will be there at the trial seeking justice.
It's going to play at the trial. I hope they give her a big advance warning, because it is hard for us to watch it. I can't imagine a mother hearing her son begging like that. You also spoke with George's brother, Ezekiel Torres. It was off camera. What does he think about what happened?
Yeah, it was really a struggle for Ezekiel to talk about his older brother, George, because for so long during this relationship between George and Sarah, the family just disapproved of it. They disapproved of Sarah. And so Ezekiel told me that when he saw Sarah and George walking toward him, he'd turn his back and walk away. And that now has led to an immense amount of regret that he has, that he didn't have a chance to actually say goodbye to his brother. So he's certainly going to be at that trial. He wants to see a guilty conviction come down, because he sees that as the only way that his brother and his family, who are just so heartbroken, can get justice.
Alex Capriello, a fantastic exclusive interview.
All right. So there you go. I just wanted you guys to see that. I mean, you know, the trial in the beginning of the trial always is so, it's sad because, it's very little about the victim in the beginning of the trial, that, well, during the trial, they talk about the crime and they talk about the victim, but it's then more focused on the defendant because obviously the state has to prove their case. And so the only time you really get to hear about the victim themselves is usually during victim impact statements. And, I just think it's important that we keep it in mind that, George lost his life, and every human being is flawed. And George was not without his flaws, right? But he didn't deserve what he got. And to me, speaking of that um, video, there are two videos, and I actually think that what's been released isn't the total length of the videos combined. Because when you read like the affidavit, the information, it seems like there's the long video and then there's the short video, and they're not incredibly long, but it just feels like the longer video, I feel like there's more to it than what's been released to the public thus far. I could be wrong. We'll know obviously when the trial comes, but before we get started even more, or before we continue, I want to take a moment to acknowledge Lariah. Thank you for becoming a member, or for being a member, excuse me, for a month. And Tony, thank you for being a member for 29 months. Wow. That's like day one. And then thank you to B Crumbs for gifting memberships. If you guys got a membership, it was either from me or for B Crumbs. Make sure you thank B Crumbs. Yeah, make sure you say thanks. So yeah, I just think the whole situation is messed up. Well, RL froze. Here's what I'll say. What I think, to me, from reading the charges against the two of them, really what it seems like is that it was a fight between both of them. And I think at different times, George, to me, what it sounds like from some of the reports that I've read is that it doesn't sound to me like George was the aggressor. It sounds to me like Sarah would take a swing or a push, and then George would react, which at the end of the day, you're not supposed to do that. You got to keep your hands to yourself. And I mean, look, the truth of the matter is, Sarah does have a fresh mouth. Okay. She does not, she's very persnickety. She comes across, she can be very combative, very defensive. I mean, she's not going to win the Miss Congeniality portion of any pageant. Okay. Let's just call it what it is. However, that is not a reason to be physical with somebody. Okay. And so, I think that it is what it is. And I do think that, I think that it's possible for both George and Sarah, when it comes to the domestic violence, I think that it is 100% entirely possible for them to both be the victim and the perpetrator, and probably simultaneously. And I do think there's some, there's that last body cam footage from before the murders where you see that it's almost like Sarah, she called the cops, but then she didn't want them she didn't want George to know that she called the cops. It makes me wonder sometimes if she did some of the things that she did so that she could come to George to George's aid, to rescue him, to save him, as it were. And I feel like as a parent of boys and girls, I think it puts me in a unique position to see it from both perspectives. You know, if it were my sons, I've raised my sons never, 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 never. I don't care what she does. You can't hit back. Get the hell out of there. Call the cops on her. Have her arrested. You can never hit her back. And with my girls, I've raised my girls. You don't hit and you don't get hit. If a man hits you, he does it once and you're out. I don't care what time of day or night it is. I don't care what the circumstances are. I don't care. Call me. I will come get you. I don't care where you are, what's going on. You know, being physical is never okay. And so I think that's a lot of where George's parents were coming from, is that, you know, when you raise your child and they become an adult and then they go and make their own choices, and you can see that this is a toxic, unhealthy, dangerous relationship, all you want to do, excuse me, is tell your kids, get out of there, get away from that. And I think and I'm sure they feel some level of guilt, because the last time that George was arrested, his parents took him in and they told him, if you go back to Sarah, we are done. And I don't blame them, because at some point, you got to put your foot down at some point. You really, you know, for your own sanity. And he went back, and it was the last time he went back. And I just think that's sad, you know, and I'm sure that they feel a level of guilt about that. You know, so yeah, it's hard. I mean, tough love is hard. Exactly, MK. It is. It's exactly that. It's tough love and it's hard. It's not easy. And I know that people think that, oh, when your kids turn 18, I don't know if anybody in here has ever seen the movie Parenthood, but Jason Rhubarb, Robards, why do I say rhubarb? Robards said in there, he has a line in there. He's like, there's no end zone. There's no end to it. You don't make the winning touchdown and you do your dance in the end zone and it's over. It's not ever. You're always still, no matter how old your children are, you're still their parent. And when they call you and they're talking to you about stuff that's going on in their lives, you're still parenting them, because you're giving them advice and you tell them, you know, from your experience and what you've been through. You know, it never, ever ends, you know? And I think that I feel bad for his family. All right. So let's get into this bill of particulars, as it were. Let me put this on the screen for you. All right. So here we go. Comes now the defendant by and through the undersigned attorney under Rule 3.140. Make it a little bigger, easier. Oh, easier. What the F? Easier on my old eyes. Of the Florida Rules of Criminal Procedure, and request this court to enter an order requiring the state of Florida to furnish the defendant with a statement of particulars concerning the alleged offense, including the following. The defendant, Sarah Boone, is charged by way of an information with a single count of second-degree murder. The pertinent part of the information states, charges that Sarah Boone, on or about the 23rd day of February 2020 in said county and state, did in violation of Florida Statute 782.042 by an act imminently dangerous to another and evincing a depraved mind regardless of human life, did kill George Torres. Under the Florida Standard Jury Instructions for Criminal Cases 7.4, Murder, Second Degree, Section You guys can read that. To prove the crime of second-degree murder, the state must prove the following three elements beyond reasonable doubt. 1, the victim is dead. 2, the death was caused by the criminal act of the defendant. 3, there was an unlawful killing of the victim by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Definitions. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. 2, is done from ill will, hatred, spite, or evil intent. And 3, is of such nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. 4, under rules of criminal procedure in Florida, a defendant has the right to know of the charges against them with specificity. Upon request, the state must provide specificity and clarification on the details of the alleged offense in order to minimize surprise at trial and ensure that the defendant's rights are protected. The rules require the information on which the defendant is to be tried shall be plain, concise, and definite written statement of the essential facts constituting the offense charged. The information fails to inform the defendant of the particulars of the offense sufficiently to enable the defendant to prepare a defense. Wherefore, the defense would respectfully request the court consider this request and grant the defense motion for statement of particulars. Okay, so let's do this right quick. Let's scroll all the way back. There's got to be more. Hold on a minute. What is happening here? Oh, here. This is what I need. I scrolled too much. My bad. Hold on. All right. Okay. So let's see what we have here for this motion of particulars. Okay, number 1, obviously, they've met their burden there. The death was caused by the criminal act of Sarah Boone. Okay. There was an unlawful killing of victim by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Okay, so let's talk about 2 and 3. Now, this is where I think to me, it sounds like what they're trying to say is that how could Sarah have known this was going to happen? How could Sarah have known that this would result in George's death? Okay, Bodine, thank you for becoming a member, babe, and thank you for gifting a membership. I appreciate that so much. That was very generous of you. If one of you guys got the gift, please thank Bodine. Okay. The depraved mind. Okay, so let's talk about that. All right. Let's talk about all of it. Okay. I think what the state is going to allege by way of the medical examiner is that George also had injuries that were sustained at the time of his death, like right before. I think they're going to use the neighbors that heard what sounded like something being thrown down the stairs, something heavy. It was loud. It rattled the walls. I think they're going to use that testimony to suggest And then they're going to use the medical examiner to prove, okay, to substantiate that, because I think that's their theory. I don't think that they're going to argue or try to prove, I think they're going to go with George got into the suitcase willingly, and he may have, okay. It might be a scenario where she badgered him and nagged him. I mean, come on, we've met Sarah, right? And he just did it to shut her up. And then she zipped him up in there, and then she pushed him down. Maybe she pushed him down the stairs. And that's how he sustained some of those injuries, because some of those injuries that he has are not consistent with simply what his cause of death was. He had other injuries. Okay, so there's that. Where the depraved mind is going to come in is going to be the video. That's what got her the charge that she got, okay? Because she's taunting him on those videos. You can clearly hear George telling Sarah multiple times that he cannot breathe. You can clearly see in the video that the suitcase is upside down. So regardless of her leaving the hole, as she says, she didn't zip it up all the way and that he could have just gotten out. He was upside down. So the part that would open for him was on the floor, making it even more difficult. And yet she continued to taunt him. And I think that is where the demonstration of a depraved mind without regard for human life is going to come in, because he clearly said he can't breathe, and he clearly couldn't get out. All right, so then let's see what the next parts are. Okay, so an act includes a series of related actions arising from and performed pursuant to a single design or purpose. I mean, she put him in the suitcase. The suitcase, you can clearly see, like I said, from one of the videos, that it's upside down. You can also see that the suitcase is in different positions, and there are marks in the carpet. To me, that's what I see, that look like drag marks, like the suitcase was moved around. Okay. Now, this is where I think that her attorney is going as far as the defense goes. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and is done from ill will, hatred, spite, or evil intent, and is of such a nature that the act itself indicates indifference to human life. Okay, well, here's the thing. If it is true that Sarah did put her son in that suitcase, or a suitcase, zipped it up, filmed it, and posted it to Facebook, arising in a CPS call, then, and a CPS visit, right? Then she certainly should have known that is dangerous, because CPS doesn't just come out for any old reason, right? Okay, so there's that. I don't know if they will be allowed to use that, okay? Because first of all, I don't know if it happened, number one. Number two, her attorney will likely argue to keep that out. If it did happen, and if there's proof of it, then her attorney would likely argue to keep that out, citing that it's prejudicial more than it's probative. It's prejudicial nature, meaning that it would unduly influence the jury in such a way that they would think it's reasonable that Sarah is the type of person to do this, rather than the state proving on its own that Sarah did in fact do this. Okay. So, and they have the video. Okay. So there's that. ill will, hatred, spite, or evil intent. I believe that is clearly shown on those videos. The things that she's saying, the taunting, how angry she is, all the things, right? That's how I feel when you cheat, etc. That to me sounds like it comes from ill will, hatred, spite, or evil intent. All of them individual, one, you can pick one: ill will, spite, hatred, evil intent. I think it was all of them to combine, but any you can pick any one of them and it would still be true. Is of such a nature that the act itself indicates an indifference to human life. To put him in that suitcase and to, I think, push that suitcase down the stairs, and then to taunt him when he's telling her that he can't breathe, for her to then go upstairs, whether she can say all day, all because she does in her interrogation video, she can claim I didn't mean to fall asleep, but you did everything that you would do in preparation for sleep. You went upstairs, you changed into PJs, you brushed your teeth, you got into the bed. Okay. Now, you fell asleep. You didn't let him out, even though you knew before you did that. And I would like to know, we only see a small time period of that video, right? They're not long. But how long between the video and when she went to bed? And then she didn't even remember that she says, she didn't even remember that he was in the suitcase. So I think that at the end of the day, hold on a minute. But the video shows it was Brian was joking, put their son in a suitcase. Where's the video? Because I still have not seen this video. Or proof of the CPS. Although I know that there is a video, I still need to, there's a video, it's kind of more like a documentary, but regardless, let's say that it happened this way. And it was Brian that did it and Sarah was there, right? And it ended up on Facebook. At the end of the day, there was allegedly, if this happened, right, there was a CPS report, which means a CPS worker came out, which means the CPS worker likely said you cannot put a human being in a suitcase. It's dangerous, right? So either way, whether she's the one that did it or Brian did it, it doesn't matter. She was told at some point not to do that. It was dangerous. Well, okay, Pumpkin Porter, where's the video? I'd like to see the video. If you could, please email me. I'll put my email in the chat because I would really like to see this video for myself. There's my email. I'm not doubting that there's a video. I just want to see it for myself. See, that's the thing about this situation. Through the history of today, thank you, Pumpkin Porter. I appreciate it. There's got to be some type of record of this somewhere. Well, and that's why I kind of say that I don't want. Yes, this is the motion after. This is the first motion that the new, other than the continuance. This is the second, I guess, motion that her new attorney has filed. And yeah, you totally could say that you could argue criminal negligence. It was the video that did it. So At the bare minimum, okay, let's take everything else off the table. Let's say there is no video of, or there was no video or allegation of the child being put in the suitcase. And by the way, he is a minor. Please don't put his name in the chat. He has nothing to do with this other than Sarah Boone happens to be his mom. He is a minor and he deserves to have privacy. So please don't type his name in the chat. And if you did before I said that, just delete your comment for me, please. I would appreciate it because I don't. Good night, MK. Sweet dreams. Have a good day tomorrow at work. Thanks for being here. I appreciate it. But anyway, please delete his. Oh, thank you, SS. Let's take the whole CPS prior incident, erase it from our minds, just take it away completely. Okay. Now, all right, let's think about this. Okay. George and Sarah were joking around. She convinced George to get into the suitcase. He gets in the suitcase. She zips him up. I think she pushed him down the stairs. Okay. But even if she didn't, okay, let's say that didn't happen either. Let's say that the suitcase is exactly where it is in the videos. That's how maybe it got moved around a little bit. Okay. But at the end of the day, no pushing down the stairs. Just take the video itself at face value. Okay. At the point that is asking her for her to unzip it, for her to let him out, right then, right there, that's it. That's what shows. Even if she didn't know when she zipped him up in the suitcase, he told her he couldn't breathe multiple times. So at that point, that's when it changed. That's when she had a duty and a right to act in that moment and let him out of the suitcase. And she chose not to. Instead, she chose to continue to taunt him, make another video, go upstairs, and accidentally on purpose go to bed. So either way, even if you take all of that away, just for the bill of particulars, just because we're just talking about this motion because they want the bill of particulars. They want, the defense wants the state to explain what evidence they have that proves this. Okay. They want specificity. So of course they're probably going to say something very, similar to what I said. They're going to use the video. Okay, but in the garden, okay. The thing about that is, okay, in the garden says, George did not get in the suitcase. She plainly said in the cop car the day she was arrested, she put him in there. She said both. She said that he got in there. She also said she put him in there. That is something that's very, very difficult to prove. And it doesn't, for the purposes of this specific motion, that isn't necessary to prove. It doesn't matter either way. I think that if the state believed that they could prove that George did not get in there willingly, they would have charged her with first-degree murder and not second. And I think that's, I think that that's something that I don't think it's necessary for them to prove in order to get her convicted of second-degree murder, which is why I think that they did go for second degree rather than first. Well, okay, this is an interesting theory. Let's talk about this one. I heard this theory today. They did play hide and seek. George hid in the suitcase in the bedroom closet to hide. Sarah Boone finds him, zips him in, and shoves him down the stairs. Well, I mean, it's a good theory. It's possible. I mean, she's super adamant that they played hide and seek. And the thing about that is that is the one thing that she has been super adamant about. We're playing hide and seek. And it's very possible that he got in the suitcase and like just held it closed and she found him and maybe zipped him in there. Maybe. I don't know. I think that because she changed the story and because I think that so George died of positional asphyxiation, which means that he was put in something that was so constraining that he could not breathe. Okay. In order for you to die of positional asphyxiation, you have to be alive first. And I think that when they looked over the autopsy and the medical examiner's findings, I think that the bumps and bruises that are on George's body, while they would be painful, they were not enough. They were not serious enough on their own to have caused his death. And so I think that is why they're not making a fuss or trying to figure out, because I think it would be, they lack the physical evidence to prove that George did not get into that suitcase willingly. Does that make sense? Did I put that right? Right. Harlot Oscara. That's the thing that's always bugged me about the hide and seek. That's not how hide and seek works. The seeker does not help the hider to hide. It just doesn't work like that. So I think that I just don't think that there is enough information. We won't know, Roro. We don't know, babe. We won't know until the trial when they talk about it. But at the end of the day, I think that they don't have the physical evidence, mainly from the autopsy report, to say that that George did not get into that suitcase willingly, freely, of his own free volition. I don't think it's something that they can prove. And so that's why it is second degree and not first degree. But I do think that this filing is quite interesting because it seems like what they're going to argue is that Sarah may not actually be guilty of second degree murder, that perhaps she may be guilty of something lesser, like manslaughter, something that carries a lighter sentence and offers the ability for. Somebody told me that Florida doesn't have parole, that offers her the ability to serve her, to walk out of prison not in a box. So Yes, Harlot says, "Are you going to cover Dee Dee's autopsy, Jen Lu? I've seen some of it already. Very interesting." Here's the thing. Yes, I am going to cover it. I have to write my request to to Greene County to get it. I don't want to read somebody else's copy. I don't want to because in order for me to read somebody else's copy, I'd have to hear what they have to say about it, and I don't want to do that. I want to have time to look over the autopsy report myself. I want to have the opportunity to research what's in it so that I make sure that I'm understanding it. One of the benefits of being me is that my mom was a histologist for 35 years, and guess who she worked with? Pathologists. And who performs autopsies? Pathologists. So I have people that I can reach out to if I want to, if I don't understand things and if I need an explanation. And I want to be able to, at this point, I think for me personally, I've followed this case for so long. And the one thing that I've always wanted to see is Dee Dee's autopsy report. And I think that the best thing for me to do is to request it for myself and look at it myself. I don't want to be influenced by anybody. So, yeah, I want to do that. See, there's Laundard JM, voluntary manslaughter, a second-degree felony that can result in up to 15 years in prison. Involuntary manslaughter, a first-degree misdemeanor that can result in up to 1 year of prison. Now, let's say this is what they go for, right? They try to get it lowered to either voluntary manslaughter or involuntary manslaughter. Obviously, involuntary manslaughter would be the ideal situation for Sarah because it can result to up to 1 year in prison. Sarah's been there she's already served 4. She's been in jail awaiting trial now for 4 years. She could, in theory, caught to involuntary manslaughter and be free right then. Period. Just on that. Okay. So there you go. That would be ideal for her. Okay. The second best thing would be voluntary manslaughter, which is a second-degree felony that can result in up to 15 years in prison. All right. Let's say that that she gets that, and they decide they're going to stick her with the entire 15 years. Well, she's going to get credit for time served at 4. She's already done 4+ years. I mean, as Sarah writes in the last few letters that she's written, it's ongoing 5 years, right? It'll be 5 years in February of 2025. So, she's already served at that point 1/3 of her sentence, so there you go. Involuntary manslaughter, though, that's really like that's a true accident. And those are very different. This is not that because of the video. See, the video is going to keep her from getting anything that light. Best case scenario, maybe voluntary manslaughter. I don't see it. I think that because of that, I think what's really getting them, what really pushes this over the edge into second degree is that video. It is the hearing him beg to be let out, telling her over and over that he cannot breathe. You can hear it in his voice that he's struggling. It's very quiet. And I even took into consideration the distance, right? She has an older iPhone. So, but even an older iPhone, even an iPhone in 2020 was still a decent iPhone. So even though she's clearly sitting closer in proximity to the speaker of the phone, obviously, and the microphone, he's still really faint. And I think that is going to be where the issue comes in. So I don't think she will get involuntary manslaughter at all. No. The video itself is what's going to do it, but it seems to me that this might be the direction that her defense goes. All right, Miss says they took it down a long time ago because of CPS. CPS explained the dangers. That's why the cops kept asking about Sarah ever putting. I didn't read this all the way through. I know that you wrote that to help Miss, and I know that his name is out there, but I just don't want it in my chat. And I didn't read your comment all the way through before I highlighted it. I just don't want his name in the. I feel bad because yeah, it's out there, but I don't have to help get it out there more. And he's just a kid, and it's not his fault that Sarah Boone is his mother. But you saying that reminds me again that of this part right here that I've been like a person of ordinary judgment, which we all know Sarah Boone is at least a person of ordinary judgment. Although if you ask her, she excels at everything. So that means that she has more than ordinary judgment, would know is reasonably certain to kill or do serious bodily injury to another. So if indeed the situation happened with her son, regardless of who it was that put him in the suitcase, it seems they were both present. I'm hearing it a couple of different ways. She was warned. They were told. So there you go. She knows, and there you have it. You know what I mean? There you have it. She's clearly at least a person of ordinary judgment. Like I said, Sarah does say that she excels at everything. She's very, very smart. And I don't think she's I don't think she's unintelligent. I do think Sarah has intelligence. So at the end of the day, bottom line point is that she is at least of reasonable and ordinary judgment. And she should have known that what she was doing was not a good idea, particularly because the victim himself said to her, "I can't breathe." You didn't know, Miss, listen, if I sounded harsh, I didn't mean to. You stay. I want you to stay. And I think what you wrote was invaluable. And I appreciate what you wrote, and you didn't know. And now you do. You didn't know. It's not a big deal. Oh, no, I don't think Sarah is as intelligent as she thinks she is, but she is, she's, at least reasonably intelligent, I don't think she's the smartest person in the room. That's for sure all the time, like she does. An ordinary person, if somebody's telling you that they can't breathe, an ordinary person would know that if they continue to say that they can't breathe, that the bare minimum, they need help. So I think, it's important. Let's see. You think she thought she killed him with the bat, so she stuffed him in, then heard him whimpering. I know that a lot, a lot of people have this theory about this bat, but I don't know about that. And here's why. You can clearly hear him say, "Sarah, Sarah, Sarah." And what I am having a difficult time understanding is why would you take out your phone to video a suitcase? I don't think she hit him with the bat. I think that, no, you can have B's name. You can have Brian's name. He's an adult. Just just the child, just her child. That's it's yeah. No, Miss, you're fine. You're good. It's just her child's name, just because he's a minor. I think that I think that I I think what happened is, it seems to me, and I've said this before, Sarah is like, we all know a person like this. We all do, who you don't really like to drink with because they're super, it's fun up until that one drink. And it happens every single time that they drink. It's just, you never know when it's going to be that drink where they go from being a fun and everybody's having a good time to being either like angry, confrontational, and belligerent, or like crying and super emotional and all that. We all know somebody like this. I think for Sarah, that she becomes the belligerent, and I think that there was probably, I don't think that it was like she said the day was. Like, she's over here, being a whole, talking about today was a good day, she damn near sings the whole song, but I don't think it was. I think that they quarreled back and forth. I think they nitpicked at each other. I think they bickered. And I think at some point, he got into that suitcase. Why? I don't know. I don't know all the things that surrounded it, but at the end, he did. And I think that right around that time is when Sarah had the drink that pushed her over to the angry side, really angry. And I think that that's what happened. And I think that, like, when you listen to that video, and I'll not play it. I've played it once on this channel. I'm not going to play it again. It's out there. It breaks my heart too much. And I know we're going to see it at the trial. And so I'll wait to see it again then, but I'll never forget it. You can hear the tone of her voice, even though she's super sloshed and slurring everywhere. You can still hear in the tone of her voice is anger. It's not fear. It's anger. And I think that she simply just didn't give a rat's fat kneecap. She didn't care. So that's what I think about all of that. Now, gosh, what else should we talk about? Yes, see, that's what I'm curious about, Miss, is if CPS is a witness or the documents or whatever, because I think that Sarah's attorney would argue that admitting those into evidence would be more, that the prejudicial nature of them would outweigh any probative value. So they're going to argue that introducing that into evidence just means that I think that it should be admitted, but for very limited purposes. I think the only thing that should be talked about is if CPS came out there and they told her and Brian the dangers of doing that. That's the only thing that should be let in. I think that's going to be the line. I don't think the whole incident is going to be allowed to come in. I think that because it's important that the jury base their verdict on the actual circumstances of the crime, not that Sarah Boone, because she did this before or saw it happen before, that she's likely the person that did this. That's not enough. they've got to be able to prove that, so, but I think if they were to let in the CPS report, that it would be like just for the limited purposes of that Sarah was told that it was dangerous. So she should have known better. Yes, Michelle. This is a pro bono attorney who responded to her advertisement, as it were. Well, Bama, I'll tell you what, let's look and see what this attorney has to say. Okay, let's do that. Bama Green Eyes says, didn't this attorney start talking with Sarah in February? The ad is in June. I don't know that he was talking to her in February. However, hang on just a second, because I might be able to answer that. Let me look at something here. Let me go all the way to the bottom of this because I have her visitation logs. These are video visits, though, not like in person. They're all video visits. Let me look at the date here. This is 2023. We need to get to the 2024s. Let's see. April, March. Let me see what his name is. Owens. All right, hang on. I'm looking for something, you guys. Just a second. Please. Give me just a second. Talk amongst yourselves. All right. So I've gone all the way. No. I can't see. Okay. So there's a video visit on January 3rd, 2024 from 4:07 to 4:21 p.m. And it and it is her former attorney, Mr. Hobson. And there is no other attorney visits after that until April 4th from 2:30 to 3:15, and that is with Miss Cashman. And then the last visit that Miss Cashman had, so that first visit she had with her there was two visits on the 4th of April, one from 2:30 to 3:15, and then one from 3:30 to 3:55. So this attorney seemingly has not spoken with her in February. Now, I can look at her official visitation, and this is, whoa, all the professional visits that she had. And it only goes up to May 24th of 2024. And the only people that are on there are her attorneys and people that it says interview, and I need to research who these people are. I don't want to show this because I don't want to everybody is aware of who her attorneys are because they went on record. But yes, he did mention that he spoke with her in August. It had not back in January or in February, but we can look. Let's just check, double check, triple check to make sure. Oh, for Pete's sake. Really? Come on, Orange County. I've only typed this in 11 billion times. I don't know why you make me type it in again. And they're going to make me take this I'm not a robot test again. Yep, here we go. I never do good at these. I'm probably going to have to take it again. Yep. Jeez. Bruh. Okay. There we go. All right. So let's look. Let's see exactly what he wrote. All right. Can y'all see that? Let me take this down. Let's look. We might have to do a part 2 of this. Okay. Let's see. Defense counsel has met with the defendant 4 times at the Orange County Jail, August 20th, 21st, 26th, and 27th. Let me see something else. I know that a lot of stuff is that there's a little bit of a buzz about this this number 5 here. During these meetings, the defendant disclosed potential exculpatory evidence on her phone in the possession of the Orange County Sheriff's Office. Evidence includes photographs, videotapes, calendars, text messages, notes, and witness names and numbers. This evidence will potentially corroborate her anticipated battered spouse syndrome defense. Okay, so that term, me too. I don't like CAPTCHA, Laura. I never do good at it, Laura, ever. I can do it when, well, because it's like click all the pictures with the motorcycle in it, right? Well, what do you click? Do you have to click just the motorcycle? But sometimes there's a rider of the motorcycle. Are you supposed to include that? And I always overclick and they make me do it again because I never know. Anywho, so a lot of there's a little bit of buzz about this potentially exculpatory evidence. The potentially part is super duper important. Okay. There is no, okay, they have her essentially dead to rights. There's a video. Okay. And unless there is a video that we have not seen where there is somebody else in that apartment also, even that isn't it doesn't make Sarah, it doesn't make exculpatory means that it proves you can be excluded as the person from, you can be excluded as the person who committed this crime. Inculpatory means you can be included in the, as a person who committed this crime. And so basically, and so I don't know that exculpatory evidence actually exists in that way, right? Are there things maybe on her phone, pictures of injuries and whatnot? Sure, it's possible. I mean, at the end of the day, truly, there are reports also. I mean, George had charges. Sarah had charges. Along with those charges are pictures, evidence, because they took pictures of the injuries. There's witness statements, et cetera, et cetera. So I don't know that this this phone is, but she is dying to get her mitts on that phone. I've never seen anything like it before. Like she super wants to get her hands on that phone for some reason. Right, Mr. GST 360. Sarah already said it was a good day. Mama cooked a breakfast with no hog, no barking from the dog, no smog. I mean, she said it was a good day, y'all. She said it was a good day. Let's see. I know I saw MP is me ask a question. Can I get Sarah's jail calls? I can ask, I can request them. Do I think I would get them before the trial? No. Do I think that after the trial I can request them and get them? Yes. 2 in the morning, ate that fat burger. Yep, you got it, Tony. Yes, Law Nerd. George's brother stated he saw him with a black eye and was told by George that Sarah threw a cell phone at him. There's absolute evidence of Sarah putting her paws on George. Absolutely. There's absolutely evidence of it. And it's sort of like when she tried to argue that she shouldn't be shackled because she's not a danger. And the officer in charge of security said, hey, I pulled your record and, here's the deal. Not only are you charged with second-degree murder, but you also have been charged with violent offenses. And she got all uppity and she said, those charges have been dropped. And he said, just because the charges were dropped doesn't mean it didn't happen. Boom. Hey, beautiful waterfall. Good to see you. Thank you for coming. Yeah, of course. I want to see. I need to know what's going to happen at this hearing tomorrow. I want to know what the judge is going to say. Oh, and I forgot to tell you guys too. So, I'm going to have to unshare Mentor Lawyer's video because it won't share because he put it on members only, which is no biggie. I would still encourage you guys to join his membership to watch the video because it's actually a really good video. But one of the things he also said in that video is that he thinks that the motion for continuance should be granted. And I don't know how I feel about that. Okay, Sarah does have the right to be represented by an attorney. She does have that right. That's part, but and if one cannot be afforded, if she cannot afford one will be appointed to her, right? Okay, she had that right, for the public defender. And all she did was basically, write letter after letter after letter after letter talking smack about her attorneys, and then has the audacity after each one of them to say, but Your Honor, I never wanted any of them to be dismissed. It wasn't my intention to fire the attorneys, but you literally called all of them unprofessional, incompetent. I believe she referred to Bankowitz as a buffoon. So why would you want somebody that you find unprofessional, incompetent, and a buffoon to represent you in a trial where you're charged with second-degree murder? I wouldn't want somebody that I thought of as a buffoon, incompetent, or I wouldn't want somebody like that. If I thought of my attorney that way, I wouldn't want them representing me for a parking ticket, let alone, I'll say this. I kind of agree with this. Mr. GST360 says, I think for the integrity of the trial, she should get a 30-day extension. As much as we hate it, it's been 4.5 years. Another month won't hurt. And you're right. It won't. It absolutely won't. It's not going to hurt anything for 30 days. But I think that's all it should be. That's it. That's all. No more. All right, let me look. Is that on Facebook, on YouTube, Pumpkin Eater? Let me see if I can find it. Un momentito, por favor. Let me look. Because if it's on Facebook, I'm not on Facebook, so I'll have to find it a different way. Let's see. No, I didn't mean that. I meant exactly what I freaking typed in. Hold on, let's see. I'm going to need a little more information than that. Can you tell me, so the name of the channel is Congenes. Can you tell me how many subscribers they have? Because there's a bunch of Congenes on here. And that would be super helpful. Because there's a lot of, well, let me do it this way. Hold on. I can do it another way. Hold on. Let me try this. Let me see. Nope, that's not going to work. Let me go back to the chat and see. Yes, Congenes, how many of those subscribers do they have? Or can you tell me what their avatar is? Because there's like a ton of Congenes. CONJ. Am I not? Maybe it's me. Yeah, no, I spelled it right. All right, hold on. Let me try by channel. See if this works. All right. I highly doubt it's somebody with 7. So let's see. Huh. Not finding it. Thank you, Pumpkin Porter. I appreciate that. It's hard. I mean, I can't find it. Okay, so Jesse says they're not getting a continuance. Judge Kranick made it clear in his order that retention of counsel would not be a reason for continuance. See, that you're 100% correct. Judge Kranick absolutely, in no uncertain terms, they were very clear that the only way that a continuance would be granted was under extraordinary circumstances. And he also said or wrote, very clearly that retaining an attorney is not, he does not consider that extraordinary results. And I think that, oh, did I? A milestone and a gift? Oh, wow. Hold on. Boss lady, thank you for being a member for 30 months. The last gift I see is Bodine. Is that right? Thank you, Bodine, for gifting a membership. I appreciate that, babe. Did I get it? B Crumbs, did I get all of it? And I think that this is interesting too. New lawyer waited to last minute to write. He has had since June and visits all August. New lawyer knew the rule. No continuing. I knew you meant 10K. But listen, you put 19K out into the universe, and I appreciate that because that is good juju. I don't know. I just see, I think that I did, babe. I did. I got Bodine's membership join. I sure did. Thank you, B Crumbs. Here's what I am interested in. Okay, besides continuing, whether or not there'll be a continuance, it seems to me that Sarah Boone, from all of her letters, right, that she is intent on taking the stand. And I need to do some more research into the battered spouse defense. But what I'll say is this: speaking as I am a Florida resident and I could be called for jury duty at some point. You never know. And I could even make it all the way onto the jury. And if I were sitting on Sarah Boone's jury, and the defense said that their defense was, the battered spouse syndrome, I would want to hear from the defendant. Would I find the defendant guilty simply for not testifying? No, I would not do that. But in that type of defense, I think that the jury would absolutely expect to hear from Sarah. And I think it seems to me that pretend judge. It seems to me that is the defense that her prior attorneys were looking to potentially use. It certainly seems an option because it's mentioned in the motion for continuance. It seems that might be the route that they're going. And if it is, and if it is, if I were on that jury, if that's what they decide to use, if I'm on that jury, I want to hear from the defendant. I'm not going to penalize the defendant for not testifying, but I definitely would want to hear from the defendant. And Neat and Hoodle, they would kick your butt off the jury fast. It was a case you covered here. I feel like, well, maybe not. I mean, there's all kinds of cases that go around all the time it's Florida, man. Yes, you're right, Miss. A juror cannot cannot give any weight to whether to the fact that a defendant does not testify as some sign of guilt. The defendant always has the absolute right not to testify. But what I'm saying is I would want to hear from the defendant. I wouldn't penalize them if I didn't, but I would want to. I think, this is where it gets sticky for me as well, because Mr. GST360 says, it's weird because I'm pretty sure her new attorney strategy was already being attempted by previous counsel. Yes. And here's the thing. Most of the stuff that was done by previous counsel has been passed along from one attorney to the next, from the old attorney to the new attorney, and so on and so forth, including Cashman, because Cashman has, the depositions that she took, and she handed that over to Sarah Boone. And I think that the judge, okay, this is where my sticking point with the whole continuance is going to be. I think that the judge, while he made his ruling on June 28th and all that stuff, and I know that when he wrote that order, he was serious about that order. He didn't make it lightly. He took a lot into consideration. He went back and looked through her case file, looked through the docket entries, everything from Judge Wooten, read the letters, read over what the attorneys said in their motions to withdraw, and then when they spoke up in front of Judge Wooten about withdrawing, he took all of that into consideration, and he didn't make this decision lightly. But I also think that I don't know what the case law is on this, and I don't know. Let's say he says no continuance. It's October 4th. You do what you do the best you can do, right? And see, what I think is, okay, so let me just finish that thought, because I had another thought while I was talking. All right, so let's say he doesn't do that. The trial starts October 7th. It's been given 3 weeks, so that's right around the 21st of October. So say on the 23rd of October, the jury comes back, they find her guilty. She's sentenced to life without the possibility of parole. Okay. So then the appeals process starts. Is this something that could be overturned on an appeal? Now, this is what I would do if I were that attorney. Okay. He said in that order that there would be no motion, there would be no continuance granted because she retained an attorney, and that he's not going to give an attorney time to prepare the case. Okay, but hear me out. Wouldn't it be smarter then to start the footwork, contacting these potential expert witnesses that you want to get to testify, right? And looking at their schedule, and then motion for a continuance based on their schedule, that they can't see Sarah, evaluate Sarah, write a report about, their results. Wouldn't that then be a reason for a continuance, because they can't fit her in their schedule? That's what I would do. I wouldn't just look the judge in the face and be like, yeah, bruh, I read your order. I know you said that you weren't gonna, I know you said that you weren't going to give a continuance because Sarah decided to retain counsel, but here I am anyway. Wouldn't it be a smarter, better idea to have done the legwork on the expert witnesses that you intend to call? The JAC has a list of expert witnesses that they work with, that will work with the JAC with their fee schedule, right? So wouldn't it be smarter to call and start making seeing what the schedule is like, and saying, well, and motion for continuance based on the expert witnesses not being available and won't be prepared by the time it goes to trial? Wouldn't that be a better way to go about it? I don't know. Oh, I wondered about that. The lawyer, what he thought about all of this. That I'm sure that there's a special. I wondered about that. Like, what if this attorney decides, man, I should have known. I should not have represented her. I shouldn't have done this. Right. New lawyer gave no time range, just trusting relationship building. I think that wouldn't it have been a better approach to just, because this is the most likely scenario that's going to happen anyway. It's late in the game, and it probably would have happened for Sarah. Let's say there was no attorney. This attorney didn't step up for her, right? She just barely got approved, and they were going to discuss it also on September 3rd. This whole situation with the JAC, they left it up to the discretion of the judge, appointing her funds for a neuropsychologist. And even Sarah did the legwork, right? She already had one in mind. Okay, so then wouldn't it be better to just like, this probably would have happened anyway. So let's say let's say the hearing went and the judge says, yes, we're going to, we're going to give you this amount of money, and you go and contact or have, your private investigator, Mr. Billy Lane, contact and make arrangements to have this neuropsychologist to come out and evaluate you. Okay. Well, that would be the 3rd of September, which leaves, roughly a month, 30 days to trial. So this expert witness would have to come and evaluate Sarah, right? And they don't usually come out just one time. It usually is multiple times, right? They come out, they do their evaluations, then they collect all the data, and then they write a report. Okay. And that report, Sarah gets a copy of, but guess who else gets a copy of that? The state gets a copy of that. And they also have to have their own experts go and do the exact same thing. So that's just my point. Why not base a continuance on the expert witness's schedule rather than, I just got here, judge? That's my point. Yeah, I mean, I'm really curious how this whole situation is going to pan out tomorrow. I really do. And I'll say this. I think that it's quite possible that this might be over by lunch with Lou, which is at noon. And if it is, then of course, as soon as the footage from the hearing is uploaded, if it's not streamed live, I don't think it will be, but if it's streamed live, I will stream it. Y'all can be right over here because I will be sitting just with you guys, and we will get through it together. But if not, which is, based on how they've done it before, it's uploaded after the fact. If it's uploaded in time for lunch with Lou, then of course that's what lunch with Lou will be about. Or I may maybe just push it till tomorrow night, just because I don't know. We'll figure it out. But either way, we're going to be talking about it. We're going to be talking about it. Anyway. Because see, if all the hearing really ends up being about tomorrow is this continuance, right? Because there's no need for Sarah or for them to make any type of arrangements for Sarah to view her physical evidence, because the lawyer is going to do that, and he can do it, whenever. But so that's not going to take any time. So it's probably most likely going to be all about the continuance. So it should be fairly short. We'll see. So maybe what I'll do then tomorrow is do a lunch with, I do want to talk to you guys about these call logs, but it's getting late and it's a school night. Even though we had a long weekend, it's going to be even harder to get up early tomorrow, and I don't want to keep you guys late. So let's just say at some point tomorrow, we are going to do a Boone-a-thon. We're going to talk about all the things. We are going to talk about what happened, whatever happens tomorrow at the hearing. I'm going to tell you guys about the call logs and the visits, because they're actually super interesting. I I'll tell you some things, right? So there's in the video visits, it shows everybody who video visits her. And I will say this, you know, Sarah had frequent visits with her ex and her son. And I don't know all the details of what she was alleging when she wanted to reopen her divorce situation. But just from the visitation, the video visitation logs that I've seen, if it had anything to do with any type of allegation that her ex was not letting her see her son, I think there's only maybe 1 or 2 times where it says no show. And this is where I had to outsource and consult with my pal B Crumbs, because there are a few visits from like Bankowitz where it says no show. And what B Crumbs and I could not figure out is when it says no show, who are they talking about? Did Sarah not show, or did the visitor not show to their video visit? Because I don't know. And it does make a difference. For example, a lot of her allegations were that Mr. Frank Bankowitz would not communicate with her. He didn't come visit her, didn't do video visits with her, etc. Well, there are some video visits that he did do, but then there are a couple of video visits where it says no show. Well, it matters. If Sarah's saying that he is the problem, but yet she's the one who didn't show, then that needs to be told, right? Conversely, if Sarah is making this allegation and the attorneys, because that's who schedules it, the prisoner does not schedule the video visit, the visitor does. So if Sarah is the one that didn't show, and yet she is complaining that Bankowitz doesn't communicate with her, that's important to know. So I'm curious, who is the no-show? When that's notated, who are they referring to? You know, so there were some interesting things like that in the record. And you can see also from the record that Mr. Padilla, for all the smack talking that Sarah Boone did about him, he actually did quite a bit of work on her case. A lot of work. There were depositions. There were motions filed. There was, standard stuff like, the demand for discovery or whatever, like that's all normal stuff. But he did do a lot of work. And also, it appears that there are several visits that are listed within the professional visits that only say interview. And so I'm not exactly sure who those people are, and I want to do a little bit more research into them. But at the end of the day, for all the smack that Sarah has talked about Mr. Padilla and Mr. Padilla did the most work on Sarah's case. I think that the next person who probably did the next largest amount of work on Sarah's case was Patricia Cashman, which was her last attorney. I think that Mr. Hobson was basically just in the very initial stages. I think he started out with, communicating with Sarah, understanding, his client, etc., getting her side of the story and all of that. And she just made it so difficult, to work with her, that he's like, I'm out. And exactly, LW, Padilla was ready for trial. What ethical violation? Something drastic must have happened. And I really, really want to know what that was. I really want to know, because he worked on her case the longest. What happened at the end? The only thing that I can really think of, honestly, is that I think Sarah wanted a defense that would have been attorneys are not allowed to lie. I know that I know that attorneys get like a bad rap, but they cannot make stuff up. I'm really curious about it. It almost sounds like Sarah wanted them to lie. Janice, it might be that they're limited on, because Sarah is indigent, they're limited on the type of expert witnesses that they can use. And perhaps there is not a neuropsychiatrist that is contracted with the JAC who will charge and take the JAC rate of pay. That might be what it is. That might be what's going on. So anyway, I've been on here for almost 2 hours, and I do want to continue this conversation. I want to give more. I want to know what happened. I'm waiting for tomorrow, and I want to really get into these visits and what Sarah says. How she is accusatory of her former attorneys, that they didn't communicate with her, they didn't do any work, they didn't, all the things that she says. But also, before I go though, the last, I'm gonna put this question out to you guys, and you guys vote in the chat by a show of 1 or a 2. All right. Will Judge Kranick grant the defense's motion for a continuance? 1 for yes and 2 for no. And I want to thank everybody very, very much for being here. Thank you so much. I would like to ask that if you have not already, would you please give your girl a thumbs up? And I will see you guys tomorrow. I'm going to play the outro now and watch your votes come in. You guys have a great rest of your evening, and be ready for the Boone-a-thon tomorrow, because it's happening. All right. Bye, you guys.
Because it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious intent or
2 minutes later.
We all do a little mad sometimes.